Shri B. Mahtab ji.
Thank you, Madam Chairperson. I would say my speech would be in three parts. The summary of the bill, which has been introduced in Parliament by the government to prohibit the practice of doping in sports. And this bill aims to establish the National Board for Anti-Doping, National Anti-Doping Agency, National Dope Testing Laboratory to provide composition, powers, and functions for the investigation. The bill lays down the procedure on the power of entry, search, and seizure in accordance with the provisions of the Code of Criminal Procedure and the procedure for timely disposal of cases involving the anti-doping rule violations within a stipulated period of 3 months. When I go back to the background of this bill, it has taken 20 years to frame this bill and bring it to the Parliament. From 1999 to 2002, the government was one of the members of Foundation Board of the World Anti-Doping Agency, WADA. Thereafter, the government signed the United Nations, the UNESCO Convention Against Doping in Sports in 2005 and ratified it in November 2007. India is also signatory to the Copenhagen Declaration on Anti-Doping. Madam, I would say when we analyze the bill, the existing anti-doping rules were adopted by NADA in verbatim without taking into consideration the realities on the ground in India. The bill formulates these rules into a legislative framework. This framework is welcome and crucial in the contemporary situation to protect the athletes' right and regulate them vice versa. The bill empowers the agency to act on their own belief to suspect any athlete. I would draw the attention of the government and also of the ministry. This creates an unreasonable, arbitrary authority in the hands of agency members to undertake to enter athletes' premises, seize any equipment, device, or substance. The bill does not provide any clarity on the protection of the data they procured from the testing or investigating the athletes. These are missing in this bill. The Ministry of Youth Affairs and Sports constituted a drafting committee comprising eminent legal luminaries, prominent sports administrators, renowned sportspersons, medical experts, and law enforcement officers from investigating agencies like CBI and Narcotics Control Bureau. And the bill addresses the recommendations of the committee report and proposes the amendments in adherence with the WADA code. But the personal data protection is missing, and that is one of the major reasons why one feels that this bill has overlooked that issue. I would say on 16th November 2020, the United States Senate passed the legislation to accordance with WADA code. It would allow the prosecution in the US of doping offenses at international sporting events in which American athletes, sponsors, or broadcasters participate. Madam, I would say the Department for Digital, Culture, Media and Sports of United Kingdom also implemented its UK national anti-doping policy framed on the pillars of WADA code. The National Anti-Doping Agency versus Josna Pansare, via a cosmetic products containing germanium oil, the prohibited substance entered the athlete's body. Similarly, in Manjit Singh versus Nada, by medication administered by a doctor specializing in sports medicine, the banned substance reached the body of the athlete. The case went to Lausanne Court of Arbitration and Athletics, where the players were found at fault and were debarred from playing for 4 years. In that scenario, one of the athletes was a tribal girl who belonged to a backwards region of our country, and it cannot be fairly expected from her to conduct research before consuming it on each and every ingredient. This reminds me of 16th Lok Sabha when I raised in this house about Duti Chand, who subsequently also participated as one of the best sprinter of our country in different Olympics and other games. And there, our society had actually was moving against her. I had raised this issue in the House, and the then Sports Minister, Mr. Sonowar, took it up, the ministry took it up, and also went to the court of Lausanne, and we fought that case, and India fought that case, I would say, and we won that case. So in that respect, I would say now, with this provision that is prevalent here today, will be prevalent here today, will help our athletes to a very great extent. Madam, Mr. Sogat Rai mentioned about the standing committee reports. Certain things are still lacking. I would say the standing committee recommended a mechanism may be laid for selection and appointment of chairperson and members of the board. This should have ensured proper vetting of the person or persons appointed by the central government. Currently, the bill does not provide for a selection process for appointment in the board. Committee also noted that the bill does not make any distinction between minor and major athletes. The World Anti-Doping Code states that the protected class of athletes includes athletes below 16 years of age, amongst others, may be given a lesser number of sanctions. The committee recommended that the distinction between minor and major athlete should be made in the rules to ensure the protective mechanism for minor athletes. I hope when the minister stands up to reply to the debate of today, can mention or may mention about the distinction between minor and major athletes. The committee also recommended, since the athlete's sporting career is limited, there is a need to ensure that the quantum of penalties is proportional to the degree of the violation. The committee noted that even after the penalty period is over and athletes have resumed their sporting career, they are not considered for national awards. It recommended that since this is a policy decision, the government has to take a note of this and can examine this issue. Regarding the laboratory, of course, Rahulji has mentioned it. The committee had recommended why not have such laboratory in each state? Why confine it only to Mumbai or to Chennai or in Kolkata? It should be because large number of younger people are moving towards the sports activities. There are, when we analyze the bill, two related issues I would like to draw here. First, the qualification of the Director General, and that is not specified. It is said that it will be notified in the rules. And second is, the central government may remove the Director General from the office on grounds of misbehavior or incapacity or, and this is more alarming, within quote, I would say, such other ground. And this gives a large scope to the administration or to the ministry or to the government that such other ground is a vast scope. Misdemeanor, misbehavior, one can understand that, and that also will be probed, and the person also can explain. But on such other ground is something which needs to be deleted from this bill. Leaving these provisions to the discretion of the central government may affect the independence of the Director General. This also goes against the mandate of World Anti-Doping Agency that such bodies must be independent in their operation. Second point I would say, under this bill, the board has powers to remove the members of the disciplinary panel and appeal panel on grounds which will be specified by regulations and are not specified in the bill. There is no requirement to give them an opportunity of being heard. This will affect the independent functioning of the panel. Madam, I would mention about specific 4 clauses of the bill. The bill, clause 14, subclause 3, clause 15, subclause 1, and clause 15, subclause 8. And these are the, I would say, in order to ensure an effective and credible anti-doping system, such organization must be independent in their ability to make operational decisions. I would say, I mentioned about the qualification, but the respective act of the regulators, such as SEBI Act, TRAI, Telecom Regulatory Authority of India, National Medical Commission of India, clearly define minimum qualification and grounds of removal of members. Giving the power to the government to decide the qualification through rules and giving discretion to decide grounds of removal will affect the Director General's independent functioning and go against the mandate of WADA. Clause number 11 and 12, I would mention. This deals with grounds for removal of a member of disciplinary and hearing panels left to be specified in the regulation. These grounds of removal have not been specified in the bill. Similarly, the bill does not specify any requirement to give members of the disciplinary and appeal panels an opportunity of being heard before removing them. Clause 11, subclause 2, and clause 12, subclause 2. WADA guidelines, I would say, requires that the members of the hearing panel
समाप्त कीजिए.
हो गया.
बोले दे. ठीक
ये हमारा रिक्वेस्ट है.
ठीक है, चलिए बोलिए बोलिए.
धन्यवाद. The bill, सोगत बाबू को मालूम है कि बिड़िया पान और कड़ा पान के बीच क्या अंतर है. The bill specifies the grounds of removal, such as convicted of an offense and abuse of position for members of the National Board for Anti-Doping, and they are also given an opportunity of being heard in such matters. The bill has not specified any requirement to give members of the disciplinary and appeal panels an opportunity of being heard before removing them. WADA requires that the members of the hearing panel should provide a collective expertise in relevant fields, such as legal, if the chairperson does not have a legal background, science, medicine, or sport, and must have anti-doping experience. That to 10 years, it is mentioned. However, under the bill, none of the members of the hearing panel are required to have anti-doping experience. That should be specified. In clause 11 subclause 2 and 11 subclause 5, the National Board for Anti-Doping in Sports will constitute a disciplinary panel for determining consequences of anti-doping violation rules. This panel will consist of a chairperson, 4 vice chairpersons, and 10 members, about which Sogat Babu said it is top heavy. The chairperson, my issue is something different. The chairperson and in absence, the vice chairperson will form the hearing panel it is not clear which of the 4 vice chairpersons will be responsible for forming the hearing panels in the absence of the chairperson. And who will make that selection? Madam, and I'll conclude here. The recent occurrence of Indian Commonwealth Games gold medalist tested positive for the usage of anabolic steroids in urine sample taken both during and after competition. The matter devolved into a dispute between the athletes and the NADA, and the National Dope Testing Laboratory in New Delhi was given special permission to test all substances taken by the athletes. The NDTL confirmed that the athletes' ginseng supplements contained prohibited substance. It was undisputed that their coach gave them these tablets. It was the Sports Authority of India's responsibility to provide for all supplements. However, after repeated requests, the coach purchased bottles of these supplements. In the end, the athletes were banned for 2 years. I would say when an athlete decides to use illegal substance, he or she is not necessarily acting alone. Coaches are under pressure to produce high results, and unlawful practices are common in every sport, creating a culture that younger athletes consider difficult to resist. Whether the provisions that we have here today, are we going to make a law here today, will desist or will create an awareness among the athletes, and also will, I would say, discourage the coaches to indulge in such activities, because the athlete is punished, not the coach. So therefore, some provisions in the rules if necessary, because you are unable to, in this position as the bill is now being discussed in the House, there will not be much scope to amend the bill now. But I would say some provisions should be made where the coach also should be held responsible. With these words, I support this bill.
बहुत अच्छा, चलिए मैं ये बोल दूँगा। अच्छा, एक चीज़ मैं बताना चाह रही हूँ कि टीएमसी की सांसद श्रीमती प्रतिमा मंडल द्वारा तथ्यहीन आरोप केंद्र सरकार पर 0 आवर में लगाई हैं। इसे लॉ एंड ऑर्डर राज्य सरकार का विषय है। बिना सबूत का आरोप लगाने का कोई ज़रूरी नहीं था कि गुमराह करने की बात आ गई है। कृपया इन्हें वक्तव्य से आप निकाल दीजिए, वक्तव्य से निकाल दीजिए। हाँ, श्याम सिंह यादव जी, श्री श्याम सिंह यादव जी। जो आरोप है उसको निकालने के लिए कहा गया है, जो बिना सबूत का है। हाँ। नहीं, जो नहीं, वो बात नहीं लिखना चाहिए, वो बोलना नहीं चाहिए था बिना आरोप। जी हाँ, सबूत आए उसके बाद लगाए, ठीक है, बिना सबूत का नहीं। बैठिए, बिना सबूत का नहीं। चलिए, श्री श्याम सिंह यादव जी।
हाँ, हाउस इन ऑर्डर। मैं
बैठिए।
हाउस इन ऑर्डर हो तो बोलें भाई।
क्या?
हाँ,
बोलने दीजिए ना, वो हम बोल दिए निकल जाएगा। लाइट दो ना, कहाँ चले गए?
शुरू हो
मैडम,
चलिए ना,
चलिए, फिर चिल्ला लीजिएगा।
एक घंटा बाद
कोई बात रिकॉर्ड में नहीं जाएगी। आप चलिए, श्याम सिंह यादव जी की बातें जाएंगी।